Hey, Professor. Uh, I hope you're doing well. Good morning. My name is Dirgh Patel, and today I'll be talking about my research in assignment number 2 in course named Law and Ethics for Forensic Investigation. So this whole I have prepared thoroughly and cited my references along way. So let's start with that. So moving to the first slide. It's all about that navigating cybersecurity ethics and legalities. So as we navigate a digital age where personal data is omnipresent and continuously at a risk of some exposure, understanding not only the intersection of uh, ethical consideration, but also it focuses on legal frameworks that becomes paramount. So today, I'll be explaining about the two critical dimensions in our digital world. The first one is about all about ethical and legal challenges related to cyber security practices, and I'll also illustrate through the case of Anthony Rose and contemporary landscape of consumer privacy legislation in Canada, primarily focusing on consumer privacy protection health, aka CPPA. So, as we start, like it is very crucial for individuals and organizations to know how to protect privacy while following the some rules and regulations like ethical standards in cybersecurity practices. So today I'll unpack both the dilemmas about the Anthony faces in the realm of cybersecurity ethics and the significant implications of the CPV on an individual rights. So I'll review ethical principles of disclosures, legal safeguards, and the broader implications of privacy legislation. I'll also reflect on how these themes resonate with my own experience and with I believe that with individual experiences and understanding of both cybersecurity and practices privacy laws. So let's start with that. So let's start with the Anthony Rose case, like which optimize the challenges of the ethical decision making within cybersecurity. So Anthony stands at a crossroads where his actions could either safeguard public safety or it will place him at a very high legal stake risk. In this discussion, I'll analyze the several key aspects of his situation, not only including ethical theories but also guiding his decision making, his specific legal obligations he might or he may face during that time, and the alternatives he has for his responsible disclosure. Moving to the second slide, it's all about that understanding some topics of cybersecurity landscapes, like about ethics and law. So, what are the cybersecurity ethics? Cybersecurity ethics not only encompasses the moral principles, but also it believe that it values the uh, professionals in protecting digital assets and information. It also involves making decisions that balances the interest of various stakeholders, various partnership, whereas including also individuals, the multinational companies, and the public. Whereas the cybersecurity law provides the legal framework for addressing cyber threats and also protecting digital information, protecting everyone's individual's privacy throughout the law. So it also includes federal and state statutes that govern data security, privacy, and also incident reporting. So moving to the next slide. So moving to the this slide is about Anthony Rose scenario into a deep dive. So I have researched about three possible scenario. The first one is about vulnerability discovery. That is one of the approach that Anthony should adhere to his structured framework. It is also recommended by the NIST, the National Institute of Standard of Technology, and in its guideline on vulnerability disclosure, this process, I think, allows him a significant vulnerability in widely used software applications. It could also potentially be exploited in many maliciously actors to gain unauthorized access to sensitive data. The second one is all about ethical and its legal implications, like what ethical legal like what Anthony must consider his actions include his responsibility and um, his guidelines to protect users while also respecting their privacies and their future concerns. Um, Legally, he needs some mindful actions to computer fraud and abuse laws, as well as consumers protection strategies. The third one is all about our responsible disclosure dilemma. Like while Anthony was facing a critical decision, like whether to disclose the whole vulnerability to the software vendor, the public, or it could even both. So no, like each option carries a potential consequences. For instance, like if he disclosed to the vendor that allows them to patch vulnerability, but it also delays public awareness. So it could responsible like disclosure dilemma. Moving to the third slide, it's all about like what were the coordinator vulnerability disclosure. So Anthony, as I talked earlier, like Anthony should adhere to the structured framework recommended by the National Institute of Standards. But its coordinated disclosure is a widely accepted industry standard adopted by organizations such as MITREA and also like CISA, like ACA known as the Cybersecurity and Infrastructure Security Agency. The approach provides some security researchers with legal protections and ensures that vulnerabilities are responsible managed before public dissemination. By working within established CVD, the coordinated vulnerability disclosure, Anthony could prevent some of the potential legal consequences associated with unauthorized disclosure, maximize the likelihood of manufacturers addressing the vulnerabilities in a timely manner. And moving to the third slide. So moving to this slide is about its ethical considerations. So what is who is for responsible for disclosure of framework? So like what were the expectations for when it's disclosed framework? So there are three types. Like first one is minimize harm. So the primary ethical consideration for minimal harm is to cut off the potential harm to users. It carefully weighs the risk of various considers factors such as how the vulnerability was severe and what was the what was the likelihood of the exploitation. The second one would be transparency. Is it crucial in building trust and accountability? If Anthony should be transparent with the vendor about his intention and timeline for disclosure, then he should transparent with the public as well as the vulnerability once it's disclosed. Third one would be respect. So, like in this digital world, respect for vendors' right is to be considered on top. If the address of the vulnerability is so much as important, Anthony should provide the vendor with a responsibility opportunity to develop and to grow within the industry. And it should allow them to deploy a patch before public disclosing the vulnerability, and it should also avoid some of the actions that could damage the vendor's reputation and its business. Moving to the third slide, what were the moving to this slide, what were the US federal and state cybersecurity laws? And I have created an overview. So there are three types of laws which US passed in recent years. The first one is CFFA, also known as Computer Fraud and Abuse Attack. The second one is State Data Breach Notification Laws. And third one is California Consumer Privacy Act, also known as CCPA. So first, I will talk about what is a CFAA. So, CFFA, it comes under Computer Fraud and Abuse Act. It is an unauthorized access to a system that could lead to legal repercussions. However, if Anthony reports vulnerabilities uh, through established legal channels, he minimizes the risk of violating federal cybersecurity laws. By also documentation his research process and working within ethical hacking guidelines, Anthony could further protect himself from such potential accusations of hacking or even in unauthorized systems access. So second one is all about state data breach notification law. So like I said, many states have such laws in to organization to notify such individuals or organizations in the event of a data breach. So in this case, Anthony should aware that of these laws and how he might apply, and if the vulnerability he discovered that it could lead to data breach. Third one is about the CCPA, the California Consumer Privacy Act. So the Consumer Privacy Act, it's all about granting California's consumers certain right and their citizens regarding their personal information. Uh, Anthony could be mindful when it comes to how his actions might impact such citizens and individuals' rights under this law. So, moving to the next slide, this is all about consumer protection statutes and its implications for vulnerability disclosure. So, there are three types in this slide also. First one is duty to protect. The second one is FTC Act. The third one is State Consumer Protection Laws. I will explain each and every implications by detail. So, starting from the first, what is duty to protect? Software vendors have a duty to protect such consumers from vulnerabilities and all, or from also protection, preventing such risks in their products. If failure to address vulnerabilities in a very limited time or in a very timely manner, it could expose them to vulnerability or to liability under the consumer protection status. The second one would be FTC Act. So FTC Act is also known as Federal Trade Commission Act. It is unfair and deceptive business practices, and not only it prohibits, but it also has authority to take such severe actions and giving them hefty fines against company that fail to protect consumer data and its rights. Third one is the state consumer protection laws. So as I said, like many such states and of course, many states have their own consumer protection laws protecting their citizens and their individuals from such preventing risk uh, that could like the it varies upon from state to state. So it is be aware that the specific requirements jurisdiction. So moving to the fourth slide, it how it balance public interest and potential harms. So there are over four. First one is social benefit, user protection, vendor rights, and its legal compliances. So what is that? The first one, like the public interest is also best served with disclosing vulnerabilities in a responsible manner that not only minimizes potential harm, it also carefully balances the need of protects the users within the user's right to access and vendor's right to address the vulnerability. Uh, and there is action should be considered by some of the ethical principles and legal considerations. Although the fourth, like the last slide is about how would you recommend your course of action by Anthony Ross. The first one should be Anthony should immediately notify the vendor if the vulnerability is happening or if the threat is like if the danger is at risk. Uh, I think Anthony should also provide them such with the detailed information and a reasonable time frame patch to solve this issue as soon as possible. The second would be to seek a legal advice. Like Anthony should hire or should consult a legal lawyer or might take a help of a specialized cybersecurity what you say like a legal professional that how to ensure that his actions are compliant within the applicable law and regulations. Also, it should coordinate the disclosure. Anthony should also work with the vendors um, together. Like if the disclosure is at risk, it should coordinate with them about the vulnerability and what are the future risks and what are the solutions that he will take. And it also ensures the vendors and users that they are protected and that they have been informed about the risk very earlier. So conclusion conclusion about this topic. So navigating like it's all about navigating the complex landscape of cybersecurity requires it's both ethical principles and legal obligations. The case of which we talked about Anthony Rose, it challenges the responsible disclosure of all the like stakeholders and the importance of informing them that the balance is interested by also compliance with the ethical framework with applicable laws. The especially cybersecurity professionals can help protect the data and its digital assets while upholding the public's trust. Moving to the second part of the question. Uh, Come to the question two of part A about the analysis of a Salesforce red team case. So, what is the this part examines the ethical and legal dimensions of Salesforce decision to terminate red team members who disclosed security tools against company policy. I'll also weigh the ethical considerations and explore the legal uh, justification cited by Salesforce, and I also analyzed to provide comprehensive understanding of the a delicate balance between corporate governance, ethical hacking principles, and employment's rights in the cybersecurity landscape. Now, moving to this slide, what were the law and wrongful terminations? So the first one is like under the ESA Act, the Ontario Employment Standards Act, employees may challenge terminations if they believe dismissal was just about the case or was just about the cause. However, since red team members unknowingly violate corporate directives, that termination may be legally justified under the for-cause dismissal provisions. Uh, so, the Supreme Court of Canada not only retains like not only proportionate the employer's action but also like if the employee can prove that their action did not constitute gross misconduct, they might have ground the legal recourse such as challenging terminations. The third one is about breaching of contractual obligations. So if the red team members were under an employment contract, their confidentiality also causes restrictions, and on external disclosures, their actions might have breached contractual obligations, further strengthening a salesperson's position. The the third slide about this intellectual property and their property and their cybercrime laws. The first one is about how the Salesforce retain ownership of the IP, like intellectual property, created by its employees, such as under Canada's Copyright Act and the Trade Security Protection Framework. It also discloses about the proprietary security tools, which may constitute a breach of IP rights. The third one is about like the employees may have some of the belief that their modification to the presentation it's avoided direct IP violation, but also Salesforce decision to terminate them suggests that the company perceived even limited disclosure as a violation uh, of corporate policy. Third one is all about transparency versus corporate secrecy. What are the ethical considerations? So this slide is all about ethical consideration. So I've chosen like the transparency versus corporate secrecy. So the red team members argued and believed that the presentations deprive the audience of knowledge, whether the corporate policies exist or to balance securities with public disclosures. However, corporate policies might exist to balance security with public disclosure, but also ethical hacking principles emphasize adherence to its employers' policies. Or not only organization must maintain transparency in their security practices, but also it builds trust within the stakeholders that they must carefully manage to avoid exploring vulnerabilities. The So transitioning to our second part of this recorded presentation, Professor, I have chosen the CPPA topic out of the five topics, and I have justified and researched all the possible questions and their answers in a very meaningful way. So let's discuss the CPP here, also known as Consumer Privacy Protection or CPP, which aims to redefine a consumer's privacy rights in Canada. Introduction of this legislation marks as a significant change in the framework of privacy protections available to Canadians and is intended for as a response to evolving digital landscape. It also analyzes and evaluates CIPA's provision in light of principles of the PPEDA also known as Personal Information Protection and Electronic Documentation Act. I'll also explore key changes and their potential impact on individuals' rights, and also examine areas where the SEPA falls short, the comparing into the stronger organization like GDP. So moving to the next slide. Moving to this slide, it's all about the Pipedia's the strengths and its weaknesses. So first talking about strengths. So Canada's existing privacy law, it establishes principles about for the collections, use and disclosure of personal information by through private sector organization. Like it creates and develops their law and maintains the principles. It also like emphasizes fairness like equal rights, right to access and correct their personal data. It also requires organizations to obtain consent for the collection, use, and the disclosure of personal information. Talking about the weaknesses, despite its strengths, PPDAS has faced a lot of criticism and a judgment for its limited enforcement powers and a lack of clear guidance on emerging privacy issues. Its principles-based approach not only inconsistent, but while its enforcement interpretations also often perceived as much as slow and ineffective. It can be also seen that it struggles to keep pace with the technological advancement, leaving such a gap in protection their customers' data collection and its use. Moving to the next slide. What are the key challenges introduced by the SEPA? So there are over three. The first one is new tribunal. Second one is it expanded powers. The third one is exceptions to consents. So first one is a new tribunal. The CP it established a new personal information and data protection tribunal to hear appeals of decisions made by the privacy commissioner. It not only expanded powers, it also grant the privacy commissioner to conduct investigations and issues orders, including the ability to impose fines for non-compliances. Exceptions, like it introduced some of the exceptions to consent requirements, allowing organization to collect and use of personal information for certain without any obligations. That's all. Moving to the So I have created some of the problems in the upcoming slides. The first problem is all about weekend consent requirements. So what is the legitimate interest? What is the de-identified data? What is the terms of service? So first one is a legitimate interest exception. It allows organizations to process personal data without consent if their interest is not working or it outweighs individuals' privacy laws rights. The second is de-identified data. It allows organizations to use or to de-identify data without their consent, even if there is a risk of re-identification. It creates a loophole that could determine or undermine the examination of privacy protection. At it, data could be re-linked to individuals. The terms of service it's as a like consent of basis, even if the terms are lengthy and complex and difficult for individuals to understand. So second problem is about reduce the accountability and for organizations. The first one is about self-regulation, like SEPA encourages self-regulations, allowing them to develop their own codes of conduct, and it also creates a potential risk that organization may set their own rules and regulations and standards privacy protection according to their risk. The second one is limited oversight. So it lacks clear mechanisms that independent oversight and accountability. The third one is whistleblower protection. Like it obviously doesn't provide any adequate protection because for whistleblower because it reports privacy violations to discourage individuals from coming forward with information and making it more difficult. Third is all about limited. Third problem is all about limited enforcement powers. So first one is about inadequate penalties, like it introduces fines for non-compliance. The maximum penalties may not be sufficient. The second one is the burden of proof, like it places the burden of proof to individuals who demonstrate that their privacy rights have been violated. If this could happen, it would be difficult for individuals to do because it is a more complex data processing activities. The third one is lack of criminal sanctions. Like it obviously doesn't have any serious like if criminal sanctions for any serious violation. This limits to avoid or to has the ability to hold individuals accountability for privacy rights. The fourth slide. The last slide is all about the differentiate between what is CPP and what is GDPR. So first, GDPR is a General Data Protection Regulation. It is a comprehensive privacy law that applies in the European Union. It protects individuals with strong rights to control their personal data and imposes strict obligations on organizations that process personal data, while the CPPA falls short because of the GDPR's several key areas. It provides weaker consent requirements. It also reduces accountability and also has limited enforcement power. While the GDPR also includes provisions for data portability and right to the forgotten, which are definitely not included in the CPPA, which includes in the CPPA. So for the conclusion, so in summary, while Canada's CPPA positions itself progressive step towards enhanced consumer privacy, but also a detailed examination reveals several shortcomings that significantly undermine its intended protective measures. As it stands without the significant amendments, the CPPA risks becoming more of a step backward in the pursuit of robust privacy protection. To address these shortcomings, an ongoing dialogue around improving consumer protections, increasing accountability, and also improving consumer protections, individuals are front and center will be centering or will be essential for fostering significant amendments. So that's it, Professor. Thank you for attention throughout this presentation, and I hope this discussion ignites my further exploration into the ethical and dimensions of secure cybersecurity and the evolving landscape of consumer privacy laws. Thank you, Professor, once again.